What are self-settled asset protection trusts? Imagine having a way to protect your hard-earned assets from future creditors while still benefiting from them yourself. That's what self-settled asset protection trusts can do. These trusts are a special tool in estate planning and asset protection strategies. They are designed for individuals who want to keep control of their assets but also shield them from potential legal claims or debts. In a self-settled asset protection trust, the person creating the trust, called the settlor or grantor, is also a beneficiary. This means they can receive distributions from the trust, unlike traditional trusts where the creator gives assets to others. The main goal is to transfer ownership of assets into the trust, so creditors cannot reach them if the settlor faces lawsuits or debts. The trust is usually irrevocable, which means once assets are put in, the settlor cannot take them back or change the rules. An independent trustee manages the trust and has full discretion over payments to the settlor beneficiary. The settlor cannot control or demand distributions directly. The trust often includes spendthrift provisions that stop the beneficiary from transferring their interest, adding extra protection. These trusts are only recognized in certain states, like Alaska, Delaware, Nevada, and South Dakota. You don't have to live in the state where the trust is created, but it must be set up and funded before any creditor claims arise. If assets are transferred after knowing about a potential claim, it could be considered fraudulent and invalid. People use self-settled asset protection trusts to shield wealth from future lawsuits, creditor claims, or long-term care costs. They allow the settlor to enjoy the assets during their lifetime while keeping them safe from legal actions. In estate planning, these trusts help preserve family wealth by protecting assets from claims that could deplete an estate before it reaches heirs. However, these trusts are complex and requiring careful legal setup. Not all states recognize them, so working with an experienced estate or elder law attorney is essential. They can ensure the trust is properly established, complies with state laws, and aligns with your overall estate plan. There are some risks. Creditors might challenge the trust through bankruptcy or argue that the transfer was fraudulent. Courts may also find ways to reach trust assets under certain circumstances. Because the settlor is also a beneficiary, courts may scrutinize these trusts more closely than traditional ones. In summary, self-settled asset protection trusts are a way for individuals to protect their assets from future creditors while still benefiting from them. They are powerful tools, but need proper legal guidance to be effective and compliant with state laws.